All right, I'll do a sound test here. Check 1, 2, test, test. They do, okay. They even mention it, okay, okay. Thank you, okay. Did you catch that? Okay. All right, we're good for time? Ready? Yep, okay. I'll wait for this gal to sit down and then we'll get going. Okay. All right. Good afternoon, ladies and gentlemen. Welcome to the monthly meeting of the City of Des Moines Zoning Board of Adjustment. This board has the power under Iowa law and the zoning ordinance of the City of Des Moines to hear and make decisions on requests for variances and exceptions from the regulations in the zoning ordinance, to review conditional use requests, and to consider appeals from any decision of city staff in the administration of the zoning ordinance. The members of this board are citizens of the City of Des Moines. They have been appointed to this board by the City Council. The board members are volunteers and receive no compensation for their public service. I'm going to take a minute here and introduce our board members. On the audience's right is Tom DeCio. Next to him is Dave Gare. Then there's Rhonda Cedillo. And on the audience's left, Heather Ann Rowe. Next to her is Justin Gross. And then Marlis Jones. I'm Mel Pins, the board chair. Our legal counsel for the Zoning Board of Adjustment to my left is Gary Guidelock. I'll introduce our other city staff who are assisting today with the process. That includes Bert Dross, the Deputy Planning Administrator, Catherine Drehas, City Planner. Let's see, who else do we have on here? Chris Heilskove, Zoning Enforcement Officer, and Eric Lundy, Deputy Planning Administrator? Deputy Neighborhood Services. I got to write that down. All right. Bert's Deputy Planning Administrator. Okay, I'll cover the meeting's procedure here today. For some of you, this may be your first time in front of us. You may hope it's the only time you're here, but we'll help you through the process. First and foremost, the Board of Adjustment is a quasi-legal board. This hearing will be conducted within the procedures and format as authorized by Iowa law and this city's ordinances. This meeting is open to the public. The meeting is being recorded by both audio and video for a legal record of these proceedings. The board members have each received a copy of the agenda and the staff recommendations. If you don't have a copy of the agenda and the staff recommendations, you can pick one up. They're in the little black trays here by the door. Feel free to grab one as soon as I'm through with my comments here. The board is required to base its decision on each item upon the criteria established by law for the type of relief sought by the appellant. The law that is applicable to each case has been identified in the written staff report. If the facts, as determined by this board, demonstrates that the criteria established by law for granting the relief have been satisfied, then the board must grant the relief. Otherwise, the board must deny the requested relief. Each item will be announced in the order that it appears on the agenda. The items that are listed on the consent portion of the agenda, which is our first section of the agenda, are not planned to be individually discussed. Rather, they will be considered for approval in accordance with the recommendation in the staff report, unless the appellant does not agree to the conditions that have been recommended by staff, or if there's an individual in this audience or a member of this board that requests that the item be removed from the consent agenda so that a full discussion on the matter can occur here at today's hearing. So I'll come back to that in a minute on the consent agenda, but just a little background on that. For the regular portion of the agenda, after an item is announced, city staff will first give a brief overview of the appeal, and they will present any written comments that have been received prior to the hearing. Then the applicant or their representative will be allowed up to 10 minutes to present their appeal. We'll then move to the public comment portion of the hearing for that item, and anyone who wishes to speak in support of, in opposition to, or in neutrality of the appeal will be allowed up to 5 minutes each to present their comments. This will be their one and only opportunity to address the board on the agenda item at hand. Once all concerned citizens have spoken on the agenda item, the board will then ask any additional questions of city staff. Lastly, the applicant will be given 3 more minutes for a rebuttal, closing comments. All speakers are requested to speak only from the podium here at the center of the room by the computer display there, and begin their presentation by first giving both their complete name and address. That address can be your place of business or residence as appropriate. In the event, you may need to be contacted for legal notices related to the outcome of this appeal. All speakers are requested to remain courteous and to focus their comments only upon those facts that demonstrate whether the criteria established by law has been satisfied. Speakers are also asked to ensure that they're respectful of time considerations, and if necessary, the board chair will limit further comments by a speaker if they exceed their time limitation. The board chair will then close any further public comment on the agenda item, and the board will immediately deliberate the request, and we will make a decision here today on the appeal. Please note that it takes at least 4 affirmative votes for any zoning appeal to gain approval. So we got a 7-member board, got to convince at least 4 of us. If your appeal is approved today, we ask that you would wait at least 1 week from today's hearing if you would need to contact the city's Permit and Development Center to obtain any necessary building or sign permits that are related to your appeal. This will allow the decision of the board to be documented and provided in the form of a decision and order, which will be provided to both you and city staff for the record. Any appeal that is approved by this board must be implemented, constructed, or otherwise utilized within 2 years of the date of the decision by this board, or such approval shall expire. Finally, the decisions of this board can only be appealed in the Iowa District Court. So if you believe you've been harmed by an error made by this board, your only remedy is to seek relief through the district court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong or should be changed, you can petition the city council to change those regulations for future considerations. Any material written or otherwise used today as part of any presentation is part of the permanent record. So if you have anything you would like to exhibit today that you haven't already given staff a copy of, you'll need to provide an appropriate copy of those items, whether it be a document, drawings, pictures, etc. And if you would like a copy of anything presented today, you can contact city staff after the hearing. Just a couple of housekeeping items. Please avoid any undue conversation in the audience so as to limit distractions during the hearing. You're doing a fine job with that. Also, please ensure your cell phone has been silenced. Sounds okay so far. And if you need to use the restroom, you don't have to go back downstairs. Just walk out the doors, past the staircase. On your left are restrooms. Once the agenda item you're interested in has been completed, you're welcome to leave the meeting. We'll have a 5-minute break in the hearing around 3 or 3:30 if that might be necessary. So we'll go ahead and take a look here at our consent agenda. These are items 1 through 5, and as I mentioned, staff is recommending approval of the requested items. We've got some conditional uses, zoning exception, conditional uses and zoning exceptions. And as long as the applicant agrees to the staff conditions, those items have been recommended by staff for approval. But I just want to do a show of hands if there would be anybody in the audience that would be opposed to this board granting the requested conditional uses and zoning exceptions listed in items 1 through 5, and I'll go through each of those quick and ask for a show of hands. If somebody does object to any one of these, then we'll go ahead and set this item aside and put it in for our regular agenda, and we'll have a full discussion. All right, item 1 is a conditional use in the vicinity of 1803 County Line Road. Is there anybody in the audience that would object to granting the conditional use as requested? Seeing none. Item 2 is a conditional use request related to Principal Park Stadium. Anybody with any concerns about that? Please show your hand. Seeing none. Item 3 is a zoning exception request at 3101 Ingersoll Avenue related to proposed signage. Is there anybody in the audience that would object to granting the requested relief there? Seeing none. Item 4 is a zoning exception at 2001 Southeast 6th Street, also related to signage. Is there anybody in the audience that would object to the board granting the requested appeal? Seeing none. Item 5, a zoning exception request, also appears to be primarily related to signage at the Des Moines Airport. Anybody here in the audience that would object to that item? Okay, seeing none. Board members, unless there's any objections from the board, would there be a motion to grant approval of the requested items 1 through 5 on consent agenda, subject to staff recommendations? Oh. Okay. All right. Moved by Marlis. All right. And second by Rhonda. All those in favor, raise your right hand. Say aye. All right. Motion carries 7-0. So if you are the appellant for items 1 through 5, you'll get a copy of our approval listing out those staff conditions about a week from today. So we appreciate you coming in for that. If anybody wants to leave the hearing at this time, we'll just take a little break here for 60 seconds, and then we'll move on to the regular agenda. Okay. All right. Item 6 is an appeal related to an administrative decision by the zoning enforcement officer, I believe, at 1453 Cyril Street. So in this case, the appellant in this case is the city. So city staff will give a presentation here to kick this off.
Good afternoon, members, chair and members of the Board of Adjustment. Eric Lundy, Deputy Director of Neighborhood Services. I was serving in the capacity of the zoning enforcement officer at the time of this original notice of violation, so I'm the one presenting in that. If you look at the code, this function is really rests with the Neighborhood Services Director or their designee by code. So any of those administrative decisions that are made in our enforcement of our codes, chapters 134, ends up being subject to appeal by anybody aggrieved of that decision. So this is what you have in front of you here today. The appellant, Dora Medrano, received a notice and has filed a timely appeal to that notice of violation, and it's being brought to you for their opportunity to challenge that administrative determination. So I'll go through the process and outline the determination that was made in this instance. The property located at 1453 Cyril Street, it's the highlighted property there on the map just north of Easton Boulevard. These are site photos taken after the application was made. This is a letter submitted as part of the application to challenge the administrative decision. That should have been included in your packet, I think. If not, I'll give you a couple seconds here to take a look at that. It essentially is challenging the fact that there's a truck that's on site that was determined to be a commercial vehicle in violation, originally described as a dump truck. I think this even goes further to say, well, it's really not a dump truck. It's a truck that's been modified with plywood panels. I think it serves as a truck that gets used to transfer roofing waste material or something of that nature. So I'll let them get into the functionality of it a little more in their opportunity. This is the sketch that was submitted with the application of the site You can see the house and the garage. That falls in line with what you saw in the aerial. This is the notice of violation that was sent on the 6th of September with the date of its inspection being on the 1st of September of this year. That notice was sent to the property owners and the contract buyers, along with the occupant, which is the same, but was sent to all those entities that you see there in the letter. And it cites the code sections that are applicable. This is the narrative provided by the applicant as part of their appeal application. Did you get this in your packet? I think you should have. Again, I'll give you an opportunity to maybe zoom in here a little bit for you to be able to read that a little easier. The appellant will have the opportunity to also go over this with you. But this was the written narrative that was submitted along with the application. And that's included as Exhibit 3. This is photos that were provided with the application by the applicant. This is Exhibit 4. And they'll have to explain what you're looking at here, because I don't think this is really related to what we were finding in violation.
Eric, just for clarification, you're saying these photos are or are not related to what you found in violation?
Well, I'm going to they were submitted by the appellant.
Oh, okay.
So I think they might be examples that they want to draw attention to.
This is not their property then?
I don't believe it is.
Okay.
It's not, it doesn't fall in line with anything that we observed during site inspection. So I think it's
Okay.
going to be,
I got you.
maybe the narrative is going to point to some of these other situations.
Mhm.
This is the violation. I'm going to go back to an earlier violation that was enforced prior to the one that we're looking at today. Just to give you some context, I want to make it clear that you were not really considering what occurred here, but I do want to give this to you in context. This was a similar type notice from about little over a year ago. It related to illegal or prohibited storage of equipment related to and materials that were related to a business use of the property that was also a residential, primarily a residentially used property. There is some allowance for home occupations, for office and so forth, but outside storage is generally prohibited in that allowance. So these were the code sections that were cited at that time. So that's going to be, for some reason it's not one, I'm going to zoom back out because we're not getting the full. That's Exhibit A. That's the notice of violation that was issued on December 6th of 2022. These were photos that went with that notice of violation at the time. So you can see examples of what was occurring last November in 2022. And what I'm trying to point out is that that was a similar scenario of what was occurring on the property at that time that was found in violation. I will say it was probably to a greater extent at that time than we are observing more with this more recent case. This is a stipulated agreement that was entered into by the property owner along with the appellant, basically agreed to prohibit or cease and remove any of the commercial storage occurring on site, including commercial vehicles. They agreed to that. That was complied with. There was another inspection that's outlined in the staff report. So there was another inspection where we released that. They paid the fines that were issued by the court. So they requested the release, which we're generally obligated to do if everything is in compliance with the court order and all fines have been paid and costs. So that was released. And then again in September of this past September, there was another notice of violation. So this activity was again coming back to the property. And this notice that was also part of the appellant's application was sent that we already referred to. It included these photos. That's kind of a distant photo, and I'll zoom in to maybe give you a little better picture of what's happening. These are all dated, so you'll hopefully see. I believe this is the main vehicle in question right here. During the inspection, I think that was actually removed from the site. And so you're seeing some other stuff going on. I know there's another trailer back here. It's possible that's being used with their business. However, it's of a nature that wouldn't be unlike somebody that had a trailer for their snowmobiles or their Harley Davidsons. There wasn't any evidence of equipment, associated with this trailer that would give evidence that we thought it was part of the business. So that was not part of the concern at the time. But there were still other things like waste tires that were on site that we noted. I might have to zoom back out here. This is a letter then. So once you get the notice of violation, there is a 10-day time period where they can file the appeal or request a written determination by the zoning officer. This is the letter that was provided requesting that determination. So you can see what they have indicated as their understanding. They essentially expressed that they did not believe that that vehicle or that truck was considered something that would have been associated with a prohibited commercial activity. I think they admitted in the letter that it was part of the use, but that they didn't think it was not customary to what you would see with residential property. They noted that it didn't require a commercial vehicle license to operate in that argument. So based on that, then there was a written determination sent back to Dora Medrano, also including all the other locate owners, basically the same addresses that were noticed of the original violation. So this letter should also be in your packet. Is that hopefully the board members had the opportunity to read through this letter. So this was this was my letter that I sent back to basically make the determination that we find that the notice was issued correctly, that the vehicle or vehicles in question and commercial vehicles used for commercial activity that are not customary to what you would see with a residential property are going to be considered in violation, and that at the end of that letter they also are prompted then to have the opportunity to file an appeal of the administrative decision, which is what's bringing us here today. If you get into the body of the letter, really mentions that there are some vehicles such as pickup trucks and vans that would be considered customary. They're the same types of vehicles that you use to drive for your own personal use as a resident of a property, and not necessarily for commercial purposes. I'll give you an example. We don't enforce on the HVAC technician that drives his van home. That van is basically the same kind of van that anyone could drive and park at their residence. It's not something that's, not customary to the residential function of the property necessarily. So we don't generally enforce on the vans or the pickups with the company logos on the side, just because we know they're used for commercial purposes. They aren't of a nature and present the same impact as something like a truck or a trailer or a boom, equipment that's clearly really only used for commercial purposes for the function of a business that's stored outside. So in that case, that's really the determination that was made in the letter. And if you have any specific questions, that should have been in the attachments that you were sent from Frank. I'm going to also show the staff report here. If you look at the zoning history, that outlines what I just went through with you in the timeline of things. Again, what the board is considering here today is really whether the character of the residential character has been violated by the intent of the code, by keeping of a commercial dump trailer, a dump truck. I'm not sure if it actually functions with a hydraulic dump, but it's used to collect commercial waste associated with the business. It's not something that the zoning officer determined was in conformance with the character of the neighborhood and would not be seen as customary or incidental to the residential use. The board at this point essentially serves then as the zoning officer. They can either decide, no, the appellant is correct, and that should be an allowed type of vehicle, and that would be memorialized in your decision. You can go the spectrum to say that the zoning officer made the correct interpretation and decision in issuing a notice of violation, and therefore that should be carried out to its extent. And you could offer anything in between to mitigate that. I think you might have noticed in the photos, there's a good chance that in current situation it's in compliance. So I would say in a normal situation, if we achieved compliance, we may not process it further to the legal process. In this case, if they were in compliance at the time that it was brought to a court hearing, there's a good chance that the only thing that we would get would be a fine. I think the hope is that we would get another agreement that would, again, allow us to go in and mitigate or remove vehicles that wouldn't comply with the court order. However, I think that they pay their fines, they could again get the release. So it's a little bit of a vicious cycle in some cases, but there's also benefit to the fact that the exercise of going through the process is a disincentive in itself. Generally, we get compliance prior to filing in legal by issuing notices. So in this case, the board could decide if they're in compliance that we wouldn't process it further to the legal process where they would be assessed fines. So that's really something that the board can now consider, is how far do we progress if they believe that the administrative decision was correct. Of course, if they believe that it's not correct, then the enforcement would in all likelihood cease there, and they would be allowed to keep that vehicle on the property with a decision and order that would back them up in that, so.
All right, Eric, can we ask you a few questions here?
Yes, I did want to show you that we got
Yep.
cards. So the little red marks, we got one from the Fairmont Park, we got one from a neighbor on East 22nd Street that essentially opposed their appeal. And then we got a neutral from the Accent Group who essentially in their comments deferred to the Fairmont Park. They did not want to make any judgment. And then this is a summary of the neighborhood meeting that was actually conducted by the appellant. And then another letter that sort of described that. And then this just shows the individual that appeared at the neighborhood meeting that was referenced. I'll go over this, Chair, and then you can ask your question. So I've presented, the next step would be that the property owner, business operator, basically the appellant would have their opportunity to present. Then you would open the public hearing for speakers in favor, against, and neutral. Then I actually would get an opportunity to come back and react to anything that was stated as kind of an initial rebuttal from the zoning officer's perspective. And then the appellant would have the final opportunity for rebuttal before the board would deliberate. So.
Please remember to put that back up later as a reminder for the
Sure.
chair.
I'll just leave it up, and if we need to move it for the
Okay.
appellant, we'll do
Yeah,
so.
and I know we have these periodically, we just haven't had one for a while, so our order of appearance is a little different. Do we have questions for Eric? Yes? Oh, I just wanted to kind of get to some questions, so I'll let you go first.
Yes, Eric, if you could put up the picture of the vehicle in question again.
Okay, and this was what was in the notice, so I've pretty much limited to the photos
Okay,
that were sent with the notices of violations.
but this is kind of at the heart of it, right? This vehicle right here that's being shown?
I think that's the example that the appellant has pointed to. They believe this should be allowed to be kept on site.
I'm kind of confused.
I'll let them respond to
I don't
that.
understand an example. I'd like to see a picture of the truck or the violation at their residence.
This is at their residence.
This is
in the notice, yeah.
Okay, okay.
Okay,
I think
Okay.
I'll let the appellant speak to the photos that were submitted.
Yeah, I'm not,
with their
I'm not worried about those. This is the truck in
This-
question at their property,
Yeah,
correct?
this was taken by the city's
Okay.
zoning inspector.
And that has sides and like a canvas top or a tarp top on it, right? Is that what I'm
Correct.
seeing? Okay.
Yep,
Okay.
and then there's a zoomed out perspective of
Got it.
that.
so I guess what I'm wondering here, because it seems like this term customary is sort of a term of art. I mean, it seems like it's a bit ambiguous. So the problem here that is pointed out is it because of the tallness and that I'm just trying to figure out specifically what is the problem with it.
Yeah,
It
so
seems
the-
like a modified truck.
Yeah, it's modified for a business use. It's of a nature, you might look at, I think a lot of things can be looked at in scale. I don't know if the scale's really that out of whack. It's certainly something that probably wouldn't be used on a typical residential function in a neighborhood setting. I know a lot of people like to do their own landscaping. That doesn't mean we want them to keep bobcats sitting out on their property,
Right.
They might use it on their property sometimes, but they shouldn't probably keep it outside on their property if it's exclusive.
We're not talking about Bobcat. We're talking
Yeah,
about this truck here.
yeah, so
that
this truck is a modified pickup truck. Had it been just a plain white pickup, I think that probably wouldn't have been a problem.
Okay.
Yeah.
So it's the issue that they put plywood on the sides and then they covered it with a
Yeah.
tarp.
It's modified for a business function.
Okay.
Yeah.
All right.
And Eric, there's no allowance here or approvals for any home-based business or home occupation at this address, is there?
So they have the right to have what we call it type 1, without
Okay.
any type
Sure,
of
sure.
review or consideration.
Yeah,
So they would be able to have their home office, for example.
right.
When they start having external impacts, like people parking on the site, coming here and dispatching from the site,
Yep.
bringing their trailers, other equipment,
Right.
then we started getting into another, should we elevate that to a type 2 or 3 home occupation? The state code gives us some leeway by categorizing home occupations into the no impact versus impact. In this case, I would say when there was outside storage, it was clearly an impact. But I think they could, conduct their business in their home, but when they have the outside storage, then that gets outside of that, so.
So I'm curious here with this photo, when you talk about customary, typical of residential, I see a very large building with what, to me, at a minimum, are probably 12-foot tall garage doors, about 3 bays. Is this a garage, a shop, a residence? What is that building?
Yeah, so that was permitted and built within the allowances for that size of property
Okay,
for residential
for residential use?
purpose. So
Okay,
we don't generally get involved in what's stored inside
I get it.
unless we have some other clear
Yep.
types of
Okay.
evidence that lead us to believe, that they're operating
Okay.
a vehicle repair with a full hoist or something, then we have
Gotcha.
to do more investigation. I have to admit it's challenging.
Yep.
And then to decide, is it somebody's hobby versus
Right.
a real business being conducted, so.
And related to that, it sounds like the real issue here is this truck, and is that customary or typical, but have you determined that there are business activities that have been occurring on this property related to some kind of use of commercial equipment and vehicles beyond a,
Yeah,
Type
so we
one.
know in the context that there was others.
okay,
There was definitely stuff that was removed and not present
okay,
at a later time.
all right,
There was a point where they were fully in compliance and we released that previous court order.
got it.
So we know there
Okay.
was a point in time where they have been in compliance, and we have evidence and documentation there was business activity.
Right.
I don't think that they're going to deny that they operate a business in Des Moines. How much of that's related to this property,
Right.
that's in question.
Okay,
We're only trying to interpret that there are some things being kept outside that would not be
Got it.
considered customary.
and that's the limit of our purview today?
That's what they're challenging, so.
Okay,
yeah.
I got you. Could you put up the letter from Dora from 9/25 of '23? Just in her handwriting there.
This thing is so,
Yep, no,
Sensitive,
thank you.
so I
I just
apologize.
wanted to read through that again, just very briefly.
is that zoomed in?
Yep, yep, this is good. Okay. All right, thank you. Any other questions? No. Okay, all right. Well, Eric, thank you. And if you wouldn't mind putting that schedule back up there. So the way.
And
they-
I'll help the appellant if they need to
Yeah.
reference their documents.
Yeah, if there's something that they want to show us or put images up there. Okay, so the property owner or representative of the Madranos, whoever that might be, please come forward. And if there might be somebody helping here today, we just like both of your names. And
Yes,
then,
my name is Valerie Kramer, and I'm an attorney, and I
Okay.
represent Dora Madrano. You need my address?
yeah, just your address of your business.
8345 University, Unit E1, Clive, Iowa, 50325.
Thank you. And then Ms. Madrano, if we could have her name and address for the record.
Yes, Dora Medrano. My address is 11212 Southeast 64th Avenue, Reynolds,
Great.
Iowa, 50237.
Okay. All right, thank you. Did you say Grimes, Iowa is your address?
Reynolds.
What?
Reynolds, Iowa.
Runnels, Iowa
Runnels.
is your address. Okay. So that's your address, but,
Yes,
Do you-
my father-in-law and me own this property.
so you own the property in question, but you don't live there?
No.
Okay, gotcha. All right, thank you. Appreciate the clarification. All right, you guys have up to 10 minutes. You're welcome to share the time however you'd like.
Yes, first I'd like to say that the truck is usually, when it comes home, it's occupied in the garage. And it is used for drywall, and it's emptied every day, and then it's pulled into the garage, and that's stored in the garage most of the time. And after September the 1st, the debris that you see in these pictures was removed, and the other trucks were taken out to be in full compliance. So the really only issue is the truck. And she would like to be able to pull it in the garage every night and pull it out in the morning. That's all the activity that there is for that truck. I also like to point out that, in the other exhibits 4 through 7. Yeah, could you? Oh, thank you. You've been a great help with those things.
It's going to take a couple seconds because it's at the front. We'll get there.
Those are the ones. Those, okay.
I can move it for you.
Oh, great.
If you have things you want to point out, each one.
Oh, Exhibit 4 is 1416 Searle, which is right down the street from this property. And there are pickup trucks there with travel trailers and also a regular truck. So those are business trucks as well. And the next one. This is 1606 East 23rd. Obviously, there's a business truck on the right-hand side. The pods is used for storage. People are using their homes as a business area and using trucks and vehicles as part of that business. Please exhibit the next one. Exhibit 6 is 1606 East 23rd. This is stored on their property. It's a camper, which is a lot bigger than my client's vehicle, and a regular truck. And then, is that it? Exhibit 7 is 1606 East 23rd as well. They have storing some kind of home-built trailer on their property. And these are certainly, some of these are a lot bigger than what's the subject truck in question. And my client built a garage specifically to put this truck in it so it would be out of sight. Now, in here, in one of the letters, it says there are vehicles allowed regularly, such as pickup trucks and vantage related to commercial use that are similar to those used by residential property owners. Dumped skid loaders, box panel trucks, equipment trailers, and lift trucks would not be considered what is customary to a residential neighborhood setting. Well, her neighbors have all kinds of box trucks and things like that, and no one is complaining. They're not before the board. And this is just a simple pickup truck parked indoors when it's not being used. I really think it really doesn't hurt the neighborhood residential characteristic. It's not stored outside. Every time the city comes in and tells them what they need to do, Dora has complied in removing all the things that don't belong there. And some of them were construction materials related to the property itself. Do you have any questions?
Yeah, do you have questions for Valerie or Dora? Heather? Oh.
So that big, large garage with 3 bays, is that the garage we're talking about?
Yes.
That you built specifically to store this truck?
Yes, she did,
And
yes.
so the truck is normally stored in there?
Yes, every night.
I guess I'm a little confused then.
Justin, did you have a question?
I just wanted to know, if Dora is actually running a business out of that residence.
Is there somebody living there?
Yeah, family members.
She has family members living there.
Okay. So she has family members living there, but is she using the property as a commercial entity?
I don't think really. She's just using that truck to store it. She was using it, and she removed everything that they required her to remove. There were some things that were there being used, and when the city came in and gave their notices, she removed them back to her house.
Okay.
So currently, she had family members living in the house, and she's using that garage to store that particular truck.
Thank you.
So does that truck get used commercially for a business during the day?
During the day, it gets used to clean up drywall.
So it is part of the business, and they store it on this property at night?
Yes, just like people who have heating and air conditioning trucks. And they work there and they bring them home.
And is that the only truck from this business that they store there?
Yes,
And it comes back every night and it leaves every morning?
yes.
Okay.
There were trucks there that were kind of disabled and things like that, and they were removed.
Okay. So Valerie, this hearing is about being focused on this property and the situation at hand, but you showed some other properties in maybe the neighborhood or here in Des Moines with maybe some, quote, large vehicles. To the best of your knowledge, has the city said that they approve of those uses? Or to the best of your knowledge, have any of those other properties you showed come to this board and been granted permission to keep those vehicles there?
I really don't know. I just think that it addresses the residential neighborhood setting. And in this particular neighborhood, there's quite a bit of storage of vehicles.
Okay.
And, I mean,
From your perspective, could those people also be violating the city zoning ordinance?
they could be. I don't really.
Has anyone
I think some
filed-
of these definitely are, because those are huge trucks.
Has anybody filed a complaint with the city of Des Moines about those other locations, to the best of your knowledge?
No, I don't know.
Okay.
I really don't know. I just presented it as a
Okay.
residential characteristic.
Related to this truck, you've made some statements that, yes, it is used for business purposes.
Yes,
You use it to haul drywall, which I would assume is drywall debris,
Yes.
right?
Yes.
So does the truck come home with debris in it, and then maybe the next day it goes somewhere?
No, my son usually tries to dump it before he gets home because he's the one who drives it, since it doesn't require a big license. So he has a normal license. He's 18.
Sure.
And so he drops his truck there, picks it up, and then goes to work wherever I sent him, and then comes back home. But he leaves it cleaning for the morning. He never leaves no trash in the streets or nothing like that because he always has it covered correctly as it should be.
Okay.
So there's no debris on streets or driveways or nothing like that for people to say we're leaving stuff behind.
Okay. When the truck is not being used to haul drywall for business activity that he's engaged in, do you use the truck to go shopping at the mall, or to go visit family, or to maybe go out on a date? What else is the truck used for?
No, we sometimes use it for other stuff, like sometimes we use it to do some lawn stuff that it's not anything to do with business, some dirt, gravel, or whatever for the home.
Okay.
But nothing heavy
But
stuff
it's
that
used
could
to
put
haul
in there.
stuff.
Yep.
Okay, I've got you. All right. Marlis?
In our material, it mentions it is unusual that there was a previous court-ordered stipulated agreement acknowledging guilt on almost the same set of circumstances under current consideration. Can you address that?
Where is that?
Well, they had issued a bunch of things they wanted fixed, and Dora went and fixed them. I don't know that the truck was part of that. I'm not really sure. The initial one, she had some materials that they were putting pavers and they were materials to improve the house. And there's some trailers. There were things on there and they removed them. The city, and then there was a vehicle that was disabled. But the truck was really not addressed in these issues, that dump truck was never addressed in the promise. It was
So this
It
is,
was junky looking, there was junk all over, and they cleaned it up. That was the first one. The second one was the dump truck and was the other truck.
because this indicates it's the same.
Pardon?
This indicates that it's the same. Am I reading that wrong?
Excuse me?
It depends, what page is that in the staff
Right.
report? And what page are you on there?
Page 3.
Okay. I don't know if that's something that can be shown briefly. Yeah. just for reference, so,
I'll respond to it when I come back.
yeah, I just want to make sure everybody's on the same page, both literally and figuratively here, that with Marlis's question, that the property owner understands what we're referencing and can respond. All right, so where are we at on this page?
Third paragraph from the bottom, I think, is what Marla's.
Right.
Yeah,
It says they're almost the same set of circumstances, but they
okay.
really weren't.
Okay. So, I want to get real basic.
Mhm.
If I got a letter from the city, or if I'd been taken to the court by the city before, I might go, hey, I'm just going to figure out a way to comply with this. So here we are today, you're in front of us, I'm assuming, Valerie, that you're probably here on some kind of, they're paying you to represent them. Why can't they just find a place to legally store the truck in a proper commercial district and pick it up in the morning? If he comes to your house to get the truck, why can't he just go to somewhere else to pick up the truck?
Well, are you guys going to help me pay? I mean, my business is kind of low right now, and for me to be paying extra rent for something that it's not necessary, when I actually paid a lot of money for that garage to be built for that, I think it's, my opinion should be that I should use it for that reason. I mean, there should no be reason why I
Okay.
should be paying extra rent.
I
somewhere
appreciate
else.
your argument, but within the context of the zoning ordinance, the business activities are not allowed to be occurring on the site. And as a cost of doing business, businesses plan for these costs to locate in a commercial district, to have secure storage for vehicles and equipment. Construction companies up off of Second and University, that's what they do. They're zoned for that, they pay for that, and they pass that cost on to their customers. That's how business works, right?
Plumbing companies, and you even made, they made a statement that plumbing companies and
Yeah.
they can bring their truck home and park it in their driveway, even though you use it full-time for business.
Sure, and we're kind of hung up on that. A
Yeah.
plumbing truck is a small vehicle, it's a van. It's primarily used for them to commute to the job. This is a very, very large vehicle. I don't know that anybody else would have a truck with a big old tarp over the top of it, sitting around in an F-350 setup. The applicant has already stated the truck's used to haul stuff, and that's it. It's not used to pick up kids after school. It's not used to just go up for a drive at Saylorville. What we're after is this customary to related uses in a residential district?
Well, they
That's
do-
what we're getting at. And Wyckoff Plumbing, a small white van, that really doesn't stick out. The other examples you showed, yeah, those stick out too. Yeah, yeah.
They're, the other one, the other ones in the
yeah. And
neighborhood.
somebody should turn those in to zoning enforcement and keep these people busy for what we pay them.
But it's what's usual and customary.
Right.
Wyckoff, I've seen fairly large vans in people's driveways, and they're not that much,
Yeah.
this isn't that much larger than that, and it is parked in a garage all the time.
Right. Okay.
Okay.
All right, so we're just asking questions. I'm done asking questions. Anybody else got any questions for the applicant or their representative? Okay, seeing none, thank you very much.
Thank you very much.
You'll have a chance to come back here to close this out, so if we can put that order of appearance back up. I think the next step is there anybody that wishes to speak in support of the city's position? Which basically that, the vehicle is not customary to residential use and setting. Speakers in support of the enforcement action. Anybody want to step forward? All right. All right, sir, we just need your name, address. You have up to 5 minutes to present your comments.
Hi, my name is Craig Moeller, and I live on 1500 East 23rd Street, Des Moines, 50317. I'm sorry, I'm nervous, and I really don't
okay.
want to be here.
Take your time.
I'm a neighbor, and this is my neighborhood, and I've been in this neighborhood for years, and in that time, we've chased out meth in this very house, way before this owner. Years ago, it was a meth house on one side of the block. We chased out a person on the other side of the block, the city did, I should say, that set himself on fire and set his house on fire. We also chased out, with the police's help, some drug activity in the street, and things were calming down, and I think we were relieved as a block. I'm happy to see the construction going on on this property because, as I said, prior to this company buying it, it was a meth house, it was a crack house, and it was awful. So it's much cleaner this way, and I wish them great success. The issues I have with it is that maybe it's because I'm retired and I have a lot of time on my hands, or I'm in my backyard gardening with my cat.
Sounds
I don't know
great.
what it is, what the issue is, but I suffer the unfortunate consequence of having ears. And when this truck is being loaded, imagine how tall this truck is. This is not a normal pickup truck. I own a normal pickup truck. I'm a contractor. I'm a retired contractor. I own a regular pickup truck, a normal one that I've used for years on job sites. This truck dwarfs my truck. I have a standard size half-ton. This truck is a 1-ton dually with 2 wheels on the back of each axle. And it's not been fun when, at any time of the day, it's not at night, it's not in the morning, it's many times during the day. In fact, today is one of those days. When debris of any kind is loaded from one vehicle into this dump truck, the noise it makes is ear-shattering, and it scares the poop out of me and my cat. My cat won't go outside if activity is going on over there because he can't stand the noise. We don't have much noise in our house because it's just the two of us. I've gone down to speak to people about this, which is a big stretch for me because I'm very quiet, very private. I can't find anyone who I can communicate with. No one will listen to me there. And the crashing and the congregation of many, 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 many people whom I don't know, all throwing things into this pickup truck, kind of come to the culmination of there's something else going on over there. It's not just a drywall company. I own a drywall company. I am a drywall company. I know what goes on. I know what it looks like. I know what it smells like. I was out on a walk 3 days ago, and in my neighborhood, around the block a few times, down the alley, up and down one side, down the other. This vehicle sat outside for at least 2 full days. I counted because I knew that I was going to need this piece of information, so it was at least 48 hours. And in the truck, in the back end, the dump part of it, was at least the front bumper, if not the entire front end of an automobile. And that's what's a lot of the problem over there. Just a company that owns a property that's going to park their vehicles would not make the amount of noise that this property makes. You know, we fought so hard to get our neighborhood cleaned up. I've been involved in some of it. But this is just, it seems like we're being victimized on the east side. This would never happen in Urbandale or Clive or any of the suburbs. Our neighborhood is being preyed upon, and rules are not being followed. And I pay a lot of taxes to live where I live, and I chose that spot specifically because I love my house. But my personal experience is very poor, and in large part because of the noise coming from that property. And as I said, I've tried many times to communicate, literally screaming to the top of my lungs. And in my 60s, this is all I've got, so no one could hear me. And I suppose that's about all I'm going to say, so that's my whole point.
Well, Craig, we appreciate you coming down today. We're always pleased to hear from not just the city and the appellants, but also residents with their views.
Do you need, pardon me for interrupting, do you need copies of the picture? I took pictures of the truck with auto body pieces in it.
That's really up to you if you have those
I
and
can,
you
and
wanted
if
to
anybody
use
wants
them
them.
as part of your presentation, but,
I wouldn't know how to get them up.
yeah, you've still got about a minute left here if there's anything you want to add.
You will have to get printouts, or is it just on your phone?
It's just on my phone.
So you have to email Eric with you.
Yeah, so, yeah, he'll need to transmit copies of those photos to the city then.
Well,
In an email?
yeah.
I'll give you my card, sir.
Yeah, so he can go ahead and show them now, and then he's got to make sure he gets them to
Okay,
you.
you want me to? That's fine.
Yep, yep.
Thank you. Is it ready? I wonder how we're going to get to be able to use these. This particular picture is a really good picture of the truck because you can see that it is not, nor has it ever been, a regular quote-unquote pickup truck. It does not just simply have wooden sides.
Okay.
It's a dump truck.
So to keep the hearing moving there, yeah, if you could just lay your phone down there, and we'll get staff to focus on those
Okay.
if possible. Okay. I don't really want to delay the hearing to
No, that's
any,
okay.
like, undue degree, but
I
if
understand.
you want to, like, pick up your phone and maybe move it toward the camera, kind of the cheat angle there to maybe see if we can get it to focus that way just for a moment. Otherwise, this doesn't appear to probably going to work for us.
I can send it to somebody. There it is.
There we go.
And there's the bumper, sticking right out of the front.
Okay.
There you go.
There we
As you
go.
can see,
Okay.
the truck next to it is a 1500 of some kind, a 1500 pickup.
Yeah.
Look how much taller the dump truck is, look how much heavier and longer, and look at the back axles. That's a dually, that's a commercial vehicle. The truck next to it is a private.
Did you have another photo you wanted to show us, or does that illustrate what you were trying to get across there?
The other illustration I'd like to make, and I've got on my pictures, is that this truck carries garbage from and to, I don't know where, but our entire neighborhood is littered with sandwich containers, cigarette containers, plastic containers that sandwiches came in, and if you walk around, the epicenter is boom, 1453, and it's exploding into the rest of our neighbors. So as they empty their trash into this truck, stuff is flying all over the place, and there's no picking it up. In fact, yesterday I found a box. Pardon, that's my cat. This is a box right behind there, right where the truck was parked, and it's brakes for a car, right next to the sandwich container. This was in their driveway. So this is an indication. All I have is evidence and what my heart tells me, but this is what's going on over there. People are coming over and fixing, cleaning, and repairing vehicles.
All right,
It's
so
some
those
kind
are the pictures you wanted to show us?
Yes, sir.
Okay. Would you be willing to take a question or two briefly?
Sure.
So I understood from the applicant's testimony that this large truck, from their perspective, someone drives over to the site and simply gets the truck, drives it away, and when it comes home, there's nothing in it. According to your testimony, it sounds 180 degrees opposite, that they're actively loading solid waste into the truck,
I
construction
believe the
debris.
truck, yes, that's what I would
Okay.
contend. I believe the truck
So they're
is-
transferring, from your observations, if you
Yes.
will, they're transferring solid waste, garbage, and debris
It
from
happened
either
over
vehicles or
lunch, yes.
people bring it there, and then it's put in that truck.
Yes, it happened
Okay.
over lunchtime today.
Okay?
People came at about 11:30, they went into the big garage, and there was several explosions that I could hear right from within my
Okay.
house, from things being thrown into the truck. So right now, if I had to guess, I'd say the truck is at 1453 Searle, parked to the garage. It's not something that goes out every morning.
All
I've
right.
watched, I have time to, I have
Gotcha.
time,
Okay?
yes.
All right, any other questions for Craig? All right, thank you for coming down today.
Thank you.
You bet. Is there anybody else that wishes to speak in support of the city's enforcement action in this matter? Seeing none, is there anybody that wishes to speak in opposition to the city's enforcement action in this matter? And that would be outside of the related party. Okay, seeing none, we have this neutrality thing. I do it just because. Is there anybody that wishes to speak in neutrality, but yet related to the issue at hand? Seeing none, do we have any further questions for zoning enforcement or city staff? Anybody from the board?
Eric, have you ever looked in these garages?
Can
Have you ever looked in the garages?
So I'm going to give you a quick lesson here on curtilage. We really can only make our inspections from the public right-of-way or any views from adjoining property owners that give us permission to view into the property. We could go up and ask if we could have access to view the garage, but I don't believe that the inspector has gotten any access to
If you
view the
suspect a
garage.
home business has taken place in the garage, do you have access to the garage, or do you have to get the permit?
No, we would have to get a subpoena or some other evidence from a adjoining property or something we can see from the rights of way. So it is a challenge for us to demonstrate some of these concerns that we suspect. Some of those examples that were shown by the appellant very well could be other items that we're enforcing in the neighborhood or have enforced and have, recidivism is common. Things show up. That probably the only thing I would say we wouldn't really go after would be the RV unless we thought somebody was residing in it.
Yeah, and I'm
Separately.
not too worried about all the other pictures. I get
Yeah.
that. That's not why we're here. And they're just using that as an example of somebody else is doing it, so why can't we? I guess I'm wondering, there's a huge conflict here between these two stories. It sounds like this truck's getting loaded on the property that it's supposed to be stored on, and it leaves every day and comes back empty. So
Yeah, we've only gotten evidence.
I'm
of
trying to
what you've
figure
been
out what's
shown.
going on. We spent an hour talking about a truck. So I think we ought to get this thing figured out. And
Yep.
obviously, it's affiliated with a commercial business. It's not a cargo van that an HVAC guy uses that's outfitted with some shelves in it because he's hauling around trades or items that he uses every day when he goes to someone's home. This truck's hauling garbage, junk, debris. So that's why I was just curious if we knew anything about what was going on in these garages.
I don't believe we've had the ability to get any evidence from what's happening in the garage.
All right.
I would point out, when we say customary and incidental, we're speaking in terms of that zoning district, the N3B district throughout the city. So, Ms. Kramer has pointed out, maybe there's some character of the immediate area where you might be able to make the argument that it might be customary, but they might be customarily violating our ordinance in that situation. So I don't know if that's a good doctrine to be looking at, from my perspective anyway. We look at the intent of the city council, what do they expect in an N3B district.
Yeah, and Eric, at the end of the day, yeah, we're not really here to determine, are they running a business or not? We're just here, the vehicle in question, is that customary within
Yeah.
a general neighborhood of the type of vehicle you'd normally see in a residential setting? That's pretty much it,
Yeah,
right?
so what they were cited for was outside storage. So in that sense, that was in
Of that
legal
vehicle.
activity.
Wow. Okay.
But other things that you've heard today about a business being operated here.
Right, that's-
We would have to cite separately, and then they could maybe challenge that to the board at that point.
Yeah.
We haven't gotten enough evidence to
Yeah.
make those type of.
Yeah, you've determined that they're storing on-site commercial vehicles that are not customarily incidental to the permitted residential use,
Correct.
right? And that's all we're here,
Yep.
gee, do we agree with that, or do we not? And that's it.
Correct.
Okay. All right. So any other questions for Eric? All right, zoning officer's rebuttal, was that yours?
Yeah.
Okay.
I was just, the only
You-
point I wanted to make was what's customarily incidental is in relation to that zoning district as it appears throughout the
Okay,
city.
gotcha.
So we would expect to
Yep.
not see these types of vehicles in an N3B district
Yep.
anywhere in the city of Des Moines.
Right.
Chair,
And we do enforce on them in many other places.
Right. Yes,
I'm not
yes.
trying to extend this, but I know Marlis had a question
Sure,
that
jump right in.
Eric was going to comment on, and it was a section about if there was the same set of circumstances.
Yeah,
yes.
and if you look
Thanks
at
for
this,
bringing that
if you
up,
look at
yeah.
the sections of the code that are cited, so it may not be exactly that vehicle was involved in the original, but certainly there was outside storage of equipment and material. We don't evaluate whether they're storing that in relation to a project on the premise. Sometimes it is obvious and we leave it alone, but, the idea is that if you're doing something on your own property, you're going to keep the things that you're using to do that a little more tidy maybe than just kind of storing them ad hoc throughout the property, so. So, yes, similar but not the same.
Gotcha. All right, anything else? Okay, all right, so the property owner, you've got the closing say here for testimony. You have up to 3 minutes. So Valerie or Dora, if there's anything you'd like to add, the floor is yours.
Dora, was that the truck with the car parts in it, was that being used for your son's personal use?
Yes, and I would not have any issues if you guys would want to look inside my garage. It's safe for business or whatsoever. Like any other person who has vehicles, if they break down and it's your own vehicle, and if you fix it, we're going to use that to throw our stuff away. That's our personal stuff from our vehicles, and it's not used for business because we don't do no auto shop, nothing like that. We do regular mechanic stuff on our own vehicles as anybody would do in their own garage whatsoever. We do not have any kind of auto shop there at all. We just do the regular as anybody in a resident home who has a garage, needs their own vehicle get fixed. It's what it's used for, or to storage our vehicles. Or the person who's living there stores their vehicles as properly in there too.
Do you have access to the alley where debris would get there?
We do not have access to the alley, as in one of his pictures that he took, if you guys saw the gate, it's locked. We locked it for a reason, for not to be going in and out, because it's dangerous for us because we couldn't see through the side of any other vehicle was crossing the street. So we decided to do was just to lock it, so we don't go in through the alley or out through the alley at all. The only entrance we go through is through the front of the house. We do not go through the alley at all. And it's locked. If you guys saw his pictures, it's locked because we wanted to save that trouble of getting hit or hitting somebody with any other vehicle, not just that truck, but any other vehicle, because we couldn't see through the sides.
Do you have any
Okay.
questions?
Any questions? Okay, thank you both.
Thank you.
Okay, we'll close the public portion of the hearing and go to board deliberation. So board members, do we have any initial thoughts on this, one way or the other? Again, I think the matter at hand here is the zoning enforcement officer's interpretation or in carrying out the code. They believe that this vehicle's presence is not customary and incidental to the residential use. That's it. That's all we're really here to determine. So, yeah.
You are essentially now the zoning officer.
Sure.
That's transfer use of the.
Yeah.
So
Yeah. So if we crawl into Eric's mind.
Yeah.
Yeah.
It's not just to determine that, it's to decide what's the next step on. Which if you look in the staff recommendation,
Okay. True. Yeah.
I probably should have said that all.
So anybody have any initial thoughts on this one? Because yes, staff recommend, I'll just go over staff rec. Staff recommends the board affirm the determination of the zoning enforcement officer and order the property owners, contract buyers, or any occupants to comply with the notice of violation for the case that was issued by the city in September 2023. And that did relate to the storage of vehicles, equipment, which this truck would be related to. Sure. Just so we can hear you.
I agree.
Okay, and why do
To
you agree?
affirm. Because it's clear there's a lot of conflict with if that vehicle truly is put in the garage every night. And it's clearly, how would we get pictures of it if it were put in the garage every night?
And whether it's put in the garage every night or not, its presence on the property itself, do you feel that that isn't incidental? That's not customary
It
with?
is not a customary
Typical. Okay.
vehicle.
Okay.
And I live in the neighborhood. And
Okay.
it should not be customary.
Any other thoughts? I like trucks. I have a Class B CDL. This is not the type of truck that you just have hanging out in your yard because you like trucks. This is an 8-bolt wheel pattern. I heard it's got duals on it. It doesn't appear to me have a regular pickup box. It looks like it just has the flatbed, or what I call the frame, and then you can build your own stake bed on it. It's got a huge tarp on top. It's got an orange construction light on it. The applicant has said, yeah, we use it for work. We're not here to determine if there is work activities going on necessarily. But the vehicle itself does not, it's not customary with what you'd see in a neighborhood. It's not incidental. Craig mentioned about, and I don't like to do this, but I agree with him. The suburbs wouldn't put up with this. South of Grand wouldn't put up with this. But why should we put up with it on the east side or the south side? My unofficial survey is 2/3 of the Des Moines neighborhoods are not stable and they're declining. And the only way to get around that is for how people care for their property. And the way they care for their property relates to the vehicles they keep there. If your car don't run, or if the tires are off flat, that's against the city ordinance. I call those in all the time in my neighborhood. I know what names I get called, but you're not going to have your junk sitting around. The same thing on large commercial vehicles. This truck could not be stored on a city street. That would violate the city's parking ordinance. Vehicles of 1 ton capacity or more can't be stored on a city street unless it's in a residential district. But that's not the issue at hand here. It's being stored on a property. But is that customary and incidental to residential use? I don't think it is either.
Are you ready to make a motion?
Sure. I'm going to make a motion. I recommend the board affirm the determination of the acting zoning enforcement officer in accordance with their authority and order all owners, buyers, occupants to comply with the notice of violation issued by the city in September 2023, which is staff rec.
I second that.
All right, second by Marlis. All those in favor, raise your right hand, say aye. Anyone opposed? All right, seeing none, it's 7-0. So staff, I would encourage you to work with the owners, occupants, residents, help them understand this ordinance, help them make their business successful. Maybe you can recommend to them where they can store this equipment. That's a cost of doing business. Okay, that'll move us on to our next item on the agenda, and that is item number 7. It's a conditional use request at 4140 Park Avenue related to limited retail sales of alcoholic liquor, wine, and beer. And Bert's going to give us the background here.
All right, Mr. Chair, members of the board, item number, Bert Ross, planning staff for the city of Des Moines. Item number 7 is a request for a conditional use permit that would allow a new business to sell liquor, wine, and beer. The subject property is located at the southeast corner of Park Avenue and southwest 42nd Street. It used to be a Valero years ago. It's been vacant for many years now. The City Council recently rezoned it from RX1 to MX3, so this zoning map here is just a few weeks behind. But please know that the council did recently rezone this property. Here's a photo, a recent photo of the building. I know years ago it came to the board for some gas station appeals, but it's been vacant since. Here's the layout that they're proposing. They're not wanting to have any fuel pumps, so this would just be a retail sales establishment. Here's the layout of the building. Again, north would be to the right. They're showing some liquor cabinets here along the west and north walls. Staff believes that they've met the criteria necessary for granting a conditional use. They're at least a quarter mile from any other establishment selling liquor, and they're not within 500 feet of any church or place of worship, school, daycare, or park. So we have recommended approval subject to 12 or 13 conditions. And I won't read through all these conditions, but they're the typical conditions that you see. There is one, number 2 is that there should not be any visible advertisements or identification of any alcoholic liquor, wine, or beer other than the generic alcoholic liquor, wine, or beer signs. But again, I'm not going to read through the rest of the conditions. Here's the consent map. We did get card in support, and actually a second card in support from a condo owner to the northwest, and then we have 2 cards in opposition also from the condos northwest of the site. So here are those cards. And this first one is from the Southwestern Hills Neighborhood Association in support of the project. This is one of the cards in opposition, just said they're opposition or opposed. the other cards in opposition. And then we have 2 more cards. And then this is just a summary of their neighborhood outreach. As part of the rezoning, they were required to do neighborhood outreach as well. So I guess that concludes my presentation. I'll just go back to the recommended conditions. Any questions?
Bert, can you explain a little bit about number 2? You pointed that out, and that must be a little bit specific to this property, is that right?
We've recommended this condition for a lot of the smaller convenience store / gas stations. If you're familiar with, sometimes they have just the buildings completely plastered with various brands of liquor or beer.
Including neon signs and windows, right?
Right. Yeah, and so this condition is intended to, I guess, reduce any visual clutter on the building.
Clean it up a little bit.
Yeah.
Okay. Thank you.
And not to focus on other cases, I certainly don't like to do that, but as Bert mentioned, we had one a few years ago at 28th and Ingersoll, the little tiny former Phillips 66.
28th and Grand. Yeah.
I'm sorry, 28th and Grand, yeah. The little Phillips 66 that's on the northeast corner. And with what they wanted to do for, I think they wanted to sell increased alcohol sales there somehow, or actual like liquor, but I believe we had that condition there to help minimize its impact on the neighborhood. So I appreciate your condition there. Other questions for Bert? So Bert, since this was rezoned, I saw that quick drawing there. Is that the official site plan drawing?
I don't believe that's the official one.
Okay.
I think it was just a
Okay.
sketch that.
I saw it was done by Seneca, which is an environmental firm related to leaking underground storage tanks. I didn't know they did those kind of things, but that's kind of cool. But related to that, there was one of the cards wanted like a fence or screening. Within the site plan requirement, will they be required to update some landscaping or maybe remove
Yeah.
some pavement to?
Yeah, they would have to meet our landscaping standards
Okay.
right now. As far as a fence, though, if there's not a parking lot back there, I
Right.
don't believe we would
Okay.
standard require a fence along here. And then the other thing to point out, there is that dry cleaner business that makes an L.
Oh, so
Around.
that's another property that actually is in between them and the residential area to the south.
Right.
Okay. But at a minimum, they'd have to comply with applicable landscaping, et cetera, with the new site plan.
Exactly.
Okay. And were the proposed hours of operation within your conditions? I'm sorry. I
Yeah,
missed
that's, I think, the first condition.
First condition. Look at that one again. Okay, so just be till 11 PM? Is that correct?
Sounds right.
Yeah, okay. All right, okay. Thank you for your present, yes?
You're welcome. No, just
Anything
say
else?
with any conditional use, it would be subject to reconsideration if the zoning officer determines
Right.
it's a nuisance.
Right, so if we grant the approval and there's problems, it can come back to us for review and either amendments or revocation. Okay, applicant or representative of the applicant. Thank you for waiting today. We just need your name, address. You've got up to 10 minutes to present your request for your conditional use.
I hope I don't take 10 minutes. I'm Ron Pogge from Hopkins and Hebner at 2700 Grand Avenue. We're here, myself and my associate, Brian McClellan, are here representing Brew Oil Company, who's the applicant in this case. It's a company owned by Inder Singh and his wife. They run several convenience stores throughout Iowa. They have 2 or 3 others that do not sell gas, and so they're experienced in the area. In order to make that a successful store, they have to have alcohol sales, which is why we applied for it and why we are here. The staff conditions are fine with us. We will accept those. I think that in response to some questions asked earlier, we do have to comply with zoning, building permits and everything else. That will include, the council is excited, it will include completion of the sidewalk around it, which is not completed now, and some other things. So I think it's going to class up the property. It's definitely going to be a plus to the neighborhood compared to a building that's been vacant for several years. So if there's any questions, be happy to address them.
Questions? I just have a very, very brief one. You know, you'd mentioned, yeah, this was a former gas station. All of the underground storage tanks and all the piping system, that's all been removed, right?
I don't
Just to
know
the best
that.
of
I
your
assume that
knowledge.
it's either
Okay.
been removed or they're in compliance
Yeah.
with the
Okay.
laws.
Just to the best of your knowledge?
Yes.
Yeah. Okay. All right. Any other questions? Okay. All right.
Thank you.
All right, brief presentation. Okay. Is there anybody here to speak in support of the applicant's request? Seeing none, is there anybody here to speak in opposition to the applicant's request? Going once, going twice, neutrality? All right, seeing none, any further questions for staff or anything zoning enforcement officer needs to say? Doesn't look like it. Okay. Then I think we'll just go ahead and go to board deliberation. We had no other testimony after the applicant's presentation. What do you guys think?
Make a motion to move to staff.
I second.
Okay. Heather, do you have any thoughts? I'm doing this on purpose.
This is in my neighborhood. I know some people who have aging parents who live over in the condos near this property had a lot of reservations at first. And so I had them watch the P&Z meeting, and then I sent them the city council meeting, and I think a lot of fears were allayed in terms of what kind of business this would bring, and I appreciate that condition that staff put on there, the number 2 as well, because, you know, I use that dry cleaners, and I go down that area a lot now that we've moved over there. And so I think that this might be a lot better than an empty building that's been vacant for quite a few years.
Thanks for letting me put you on the spot on that one. Yeah. Okay, so we do have a motion by Dave. We have a second by Marlis to approve the conditional use request subject to the staff conditions. All those in favor, raise your right hand, say aye. All right, seeing no opposed, motion carries 7-0. Okay, so that'll bring us then to item 8, which is a use variance at 1900 Arlington Avenue related to use of an existing structure for a multiple household residential use. And Catherine's going to present the background on this.
Chair, members of the board, Catherine Dreyhaus, planner for the city of Des Moines. As mentioned, this property, the subject property is 1900 Arlington Avenue, and it is before you today for a use variance that would allow the existing structure to have up to 7 dwelling units. The subject property is located at the intersection of Arlington Avenue, where it curves south and intersects with Franklin Avenue. A few site photos taken yesterday. As you can see, this is a house that was converted after 1957 into a multi-family house. I'll go through a little bit of the history in a few more minutes, but just gives you a little bit of context of the current condition. And I did include the Sanborn map from 1957. You can see that at this time it was not noted as being converted into multifamily housing. I also included a copy of the letter of zoning determination that the appellant requested when this process began. We can come back to it for reference if you have any questions about what was provided to the appellant at that time. And then the appellant also provided us a copy of project narrative. Looks like a couple of you might be looking at that, so I will zoom in. We'll take just a few minutes to go through it.
So this document was created by the appellant?
This was created by the appellant and submitted as part of their application.
Okay.
I'll let Mel give me the nod when he's ready for me
Oh,
to...
it's up to my colleagues here. We'll try to follow along here. All right, you can probably scroll down a little bit. There we go.
And if you have any questions about this document, I'm sure the appellant would be the best person to ask those questions for.
Maybe one more paragraph, yeah. Okay. Everybody good? Okay, all right.
And so I'll give you a little bit of the history from the staff's perspective. Earlier this year, I believe it was May or June, the appellant reached out to staff to begin a process of replacing windows and upgrading the exterior egress as part of reobtaining the rental certificate. They knew that they were in a local historic district, and they knew that they would need to go through the HPC process, and they just asked us to come out and do a site visit, go through a few of their plans and what they plan to request when they went to HPC, and kind of do a pre-application type meeting on site with staff, with a few members of staff. Mostly it was staff representing the Historic Preservation Commission in our capacity of supporting the commission, and then we had one member of code enforcement who was also on site. During that conversation, we realized that there was a chance that the property had lost its non-conforming rights. It is zoned N5, which does only allow single-family household residential use. And when we did the code update in 2019, essentially it was grandfathered in from having already had a rental certificate for 7 units on the property. It was allowed to continue as a legal non-conforming use so long as they maintained a continuous rental certificate and renewed it on time, essentially. The appellant can kind of go into more of the background of how they picked up the property and kind of what happened, but in the process of before they acquired the property, the rental certificate lapsed, and then after 1 year without a rental certificate, it lost its legal nonconforming rights. All of this is detailed in the letter of zoning determination from the zoning enforcement officer when the appellant requested it, so we can go back and look at that if needed. The appellant was advised of a couple paths forward. They chose to go forward with a rezoning request, requesting all seven units. So that required rezoning to NX 1 or 2. I'm sorry, I'm forgetting off the top of my head at the moment. And then that request went through the process. It was ultimately denied by City Council in November of 2023, and that is how the property is now eligible to request the use variance that is before you today. At this time, staff is unable to find that the appellant meets the conditions for granting a hardship, so staff is recommending denial of the request for the use variance. However, should the board determine that the appellant has met the criteria for granting a use variance, we have included a few recommended conditions of approval, and those include no more than 5 dwelling units on the subject property, and there shall be no more than 5 off-street paved parking spots on the site. Those are pre-existing parking spots that are there today. Any emergency egress for the structure shall be fully enclosed, and then our standard condition that they have to comply with all of our site plan regulations, various codes that the city enforces, issuance of all necessary permits, included in that obtainment of any necessary certificates of appropriateness from the Historic Preservation Commission. We do have a summary from the appellant of their neighborhood meeting requirement outreach. They did this for the rezoning process. It looks like in August 24th. And then we have a consent map from the notification process for the use variance. As you can see, the properties within 250 feet have come back generally in opposition. And I will note that this property, if you can see the cursor a little bit, labeled Fair Play Properties, submitted a letter of opposition late last evening, and it is included further on. We just did not have the time to include that on the consent map. Consent cards, I'll zoom in so you can read those. We did receive both a card, and then the next slide shows the letter from the Neighborhood Association president.
Okay. All righty.
And then we did receive, in addition to the notification process with comment cards, we did receive a number of emails. The next few are from either people close to the 250-foot boundary or within the Riverbend neighborhood. I'm going to have to zoom out a little bit. That might be a little hard to see, I apologize.
Okay.
This was the property that is within the 250 feet, but was not included on the map.
Okey-doke.
And then the next set of letters are letters of support from outside, as best as staff could determine, from outside the 250 or the Riverbend neighborhood.
And Catherine, as you're going through these letters, I see The applicant's Starlink LLC, but I keep seeing all this support for Credo Capital. Are they a related entity?
They are related entities. I believe Credo Capital might be the primary business name, and then they owned various properties throughout the city under other LLCs.
All right, thank you.
Sorry, skipped one there.
Okay.
I believe this is a two-page letter, so.
I like your scanning speed there. That works good.
Oh, okay.
If anybody's not a speed reader, please let me know.
I'll slow it down just a touch, but keep it moving that way. We're not taking up quite so much time.
You're doing fine.
Oops. This is another two-page, I believe. Guess it was just one page. And that brings us to the end of the various letters that we received. If you have questions for staff at this time, I'd be more than happy to attempt to answer those.
Justin.
Thank you. So the N5 designation is the N5 designation to reduce density or to support density?
So it is currently zoned N5, and that happened with the zoning code update and the map update in 2019. And then it had a pre-existing rental certificate at that time. Staff is not entirely sure how it ended up as N5 instead of N5-4 or NX1 or 2 as other properties in the neighborhood did. But it was allowed with that existing rental certificate to retain its legal nonconforming rights at that time. And in the years following, it continued to update, the property owner at the time continued to update the rental certificate until about, it's in the letter of zoning determination, I believe it was in 2021, when the rental certificate expired. They're given a year to get that renewed and retain their legal nonconforming rights. And in 2022, since no rental certificate had been applied for at that time, it lost its legal nonconforming rights.
In other words, okay. I guess what I'm trying to figure out, it sounds like the city is supportive of having high density typically, but it sounds like from your presentation that the N5 designation is sort of against having high density. Is that
The N5 designation would only allow single household use.
Single-family home.
A single household, yeah.
Okay.
And so since that is the current rezoning, and then the rezoning application by the appellant earlier this year was denied, it is still zoned N5, and thus the only use for it is a single-family,
Okay.
single household use.
Got it. Thank you.
Yep.
Yeah.
When did this property sell? It sounds like the
The
current owner bought it, didn't realize that the certificate was going to lapse, and it lapsed. Is that?
My understanding, and if you don't mind, I'll go back to the zoning, the letter of zoning
Yeah.
determination, because it has a little bit of the history. Well, you know what? I put it in the staff rec, and it might be easier to follow there. Let's see. So the last valid rental certificate expired, I'm sorry, in 2020. The non-conforming use was discontinued in 2021 following the one-year lapse in renewal of that certificate. And then the Polk County Assessor's webpage notes the recorded sale date as April of 2022. So it had lost its, it did not have a rental certificate at the time that the assessor records the appellant as having purchased it. And then I don't believe they were aware of the fact that it would lose its legal non-conforming rights at the, unless they requested a new rental certificate before that one-year lapse. And so I believe it lapsed during that time. And then earlier this year is when we heard from the appellant regarding window replacement and exterior. So they did put in an application sometime after it had lapsed to renew the rental certificate. It failed the rental inspection, and they reached out to staff to discuss how to start getting some of those issues that needed to be updated resolved. And since it's in a local historic district, they came to staff for an HPC request initially.
So they had lost the certificate. They had a year to get it renewed.
So
And in that period of time, they had bought it and didn't realize it. But this sounds like a pretty educated property management company based on all the criteria we've seen from some of the other recommendations and other properties that they've renovated.
I think they've had a thorough education this past year. And so
But they're a pretty experienced company at what they're doing.
they have a
too.
number of properties elsewhere, but they aren't in local historic districts. I think they just picked up local historic district properties in the last year and a half.
But even if this wasn't in a historic district, if a rental certificate expired, potentially in other districts, some things could lose non-conforming status, correct? In
Correct,
other
yeah.
situations that may or may not be present.
Yeah, and the
Right.
appellant will have to kind
Yeah.
of,
So I guess what I'm trying to understand is when did they decide that they wanted to get this reinstated? And how long after it has expired and they couldn't get it, but they owned the property, did they decide that? It's almost like they're trying to decide what to do with this property. Now they're at, well, this looks like a pretty good deal. Let's try and get this back.
I'll have to let them kind of clarify that for you.
But they didn't buy it until 7 months after the year had gone through, yeah.
Yeah,
Marlis
I'd
is
say
correct.
let's, rather than have discussion between us, let's wait, listen to the applicant, and get their side of the story here on that stuff. I understand everybody's concern, but let's listen to them. Any other questions for Catherine? Catherine, I do want to come back to one thing, just to make sure this is clear for everybody. So we have a relatively new zoning ordinance. I've been around a long time. It used to be, R1, R2, and, and C1, C2. But with the N district, generally that means residential, it means neighborhood.
Correct.
But the 5 has nothing to do, I see here that if we're inclined to grant a variance, no more than 5 dwelling units, that 5 has nothing to, those 2 5s have nothing to do with each other.
That is correct. Those 2 5s have nothing to do with
In
each other.
5, the neighborhood number 5 district relates to the general type of housing as single-family, either size, age, design, style, correct?
Correct.
So N5 is a single-family housing district
Correct.
under the new ordinance. Yeah, because I saw the 5s here at the end, but nothing's related to that.
The rationale from staff is that should you find that they meet the criteria for granting a hardship,
Sure.
there are 5 pre-existing parking spots that are legal,
Okay.
not essentially legal non-conforming spots on the site, and so we linked that there'd be the
I gotcha.
parking and the number of units that would be that staff could support to that parking element if we could support the hardship.
Right.
And staff did recommend 5 units because of the parking during the rezoning process.
I got you. Yeah. Okay. All right. Anything else for Catherine? All right. Well, let's go ahead and get to the applicant. They've been sitting patiently for some time. All right. Applicant or representative of the applicant, we just need your name and address as appropriate. You've got up to 10 minutes to give your request for your variance here.
My name is Becky Hugh. I live at 112 10th Street, apartment 309, Des Moines. So I'm here to represent Starlink and Credo Capital. This is my 4th time presenting similar facts, so
Okay.
some here might be, it's repetitive, but.
And Becky, I'm just curious, are you an officer of the company or?
I am the managing member of
You're-
Starlink
okay,
and
okay.
Credo Capital.
All right. Got you. Thank you.
Yep. So I'm going to tell a little bit of story about us first, just give some context. And many comments were made about the fact that we're experienced, we are, but I'll elaborate on what happened. So this is our vision and mission. I've been in Des Moines 15 years. We started this little company as a hobby about 10 years ago in a single family. Rented out rooms to housemates that moved on and started buying more homes over time. I have a full-time job. All my partners have full-time jobs. We met in school at Drake University. We decided to stay in America for a host of reasons. So we buy houses through the value add proposition. So these are the 4 partners. We're all Malaysian, but we love America. We're here for the long haul. And we have 2 full-time employees as of this year. Sheena is with us here. She's our asset manager and property manager. And we have Zach Dredge, who is our full-time maintenance technician. We actually poached him from a corporate job, so he liked what we do, and therefore he joined us. So this is something called the Burr strategy. It's easy to remember, made famous by Bigger Pockets. So you buy something, you rehab it, and you form some margin there, and then you rent it out and refinance, and you repeat that process. So we did that over the last 10 years and have been successful in accumulating close to 20 buildings and 100 units, all in Des Moines, with the exception of 1 in Valley Junction with a West Des Moines address. We love Des Moines, been here a long time. I've seen everything change from what happened at the Drake University area. I went to school there, I lived there, and look at it today. So pleased with what has happened over the last 10 years. Some pictures of properties that we bought before and after, just to show a track record. Before, after, we stage our properties and we professionally take pictures and put them on our websites. Another one, before and after. Single family home, difficult situation with the former ownership, before and after. This is something we did with Invest DSM. We piloted the landlord program. It's now rental to a family, before and after. So this is what happened. So we became owners in April of 2022. We bought 1900 as a 7-unit apartment. It's part of a 16-unit buy. So the houses in between are owned by us as well. We bought it as a portfolio, bank receivership from the previous owner who owned it for a day and flipped it to us. So the title was clean. Everything seemed okay. We did not know that this was not going to be, a downzoning was not something we're familiar with. So every property we've bought in the past, we have managed to buy with rental certificates are valid. We did buy one in Riverbend that is zoned single family, 1908 8th Street. It was downzoned from a 5-unit to a 1-unit, but we bought it as a 1-unit. So it's part of underwriting. We're a business. And every evidence at acquisition with the broker who's bought, with us sold and bought with us a long time, they know that we buy multifamily because that's the business plan going forward. It's very challenging having single family spread out all across Des Moines, and we have a mission and vision to change some lives. So it's a very difficult portfolio, and the question was asked earlier, why did it take so long before it was known to us? The property came with three tenants on the rent roll out of 7, 4 were vacant above it, and it took us 8 to almost 10 months getting those people out. The court system was backed up. It still is a pandemic outcome. It just took a long time. Some neighbors here could attest to the noise and just damage that some of the tenants that we inherited came, and that's not our tenant pool. We have a very rigorous background check, credit check, income check, like all the usual stuff that a property management company should be doing. So we found out in May through that visit that Catherine talked about, and we've already rehabbed 4 of the 7 units on the top floor because we wanted to get moving on the 3 remaining units as soon as they got evicted. So here's a series of events. So we started a pre-app meeting. We went through the whole process. We went to 2 P&Z meetings. The first one took 3 hours long. It was a very hotly debated meeting. We had a second one so that we had more time to talk to the neighbors, which we did. We even, the city even reached out to us and said, hey, you guys should think about the CDBG grant. We did apply. It's 30 pages long. So we are willing to make this an affordable apartment in exchange for funds shared 50-50 between HUD, the city, and us. So we still need to put up a fair bit of money and capital into getting this project done. City Council meeting happened on 20th, and as I think I've alluded to, Josh Mannebaum and Chris Coleman made comments that the BOA process is probably a better process because of the conditional use that can happen with it. A permanent rezoning wasn't really our intention in the first place, to be honest. So part of me, if I could look back, I would have fast-tracked it to this process instead of trying to go through a permanent rezoning, because we bought it as a building that was 7 units and has been that way since 1957. So some quick defense for why. Local management, that was one of the concerns. We are here. Affordable housing, our average rent is less than $800 a month, so you just need to make $30,000 a year using a 3 times income methodology to qualify living with us. A lot of our tenants are people of color, more than half of them are. A lot of them are single parents. Some gave their testimonies during city council meetings. Some wrote letters of support. We try to have a really good relationship with the city. They've been really good to work with, and we've had a really great interaction so far. And we strive really hard to make our neighbors safe through the conditions that we just talked about. Mm-hmm. So this is something I'm still a little bit confused about, and I want to clarify even with the city in general. So this is our first time here in BOA. We hope to never come back, of course. Yeah, so it's a very, very, very expensive, costly, timely, tiring tuition lesson. I've learned a lot, made some good friends and maybe some enemies, but we want to stand firm with this. So just frankly speaking with data, because we're data-driven people as well, if this were a single family, I had a broker come out and say, give me some comps. And I think some of you here have that experience being there. If this were a single family today, what can you sell it for? Maybe 180, 360,000. It's a big house. But to restore it to a historical single family rent house, I think it's personally more than $150 a square foot to build. So simple math says, it's 500 plus to restore it. I have some broker comps for a single family right there. And I have a list of just sensitivities. If we were to keep it at 7, what's the value? 6, 5, 4, 3, 2, 1. And some of these numbers are TBD because we still don't have clarity on what it would look like. And therefore, it will be very difficult to estimate, frankly, what it would cost to redo certain things. But as the lower the density, the worse the outcome is. So I was a bit confused as to the hardship comment, because I'm like, yes, we are in hardship already in some sense. We will be in more hardship if it were to be in reduced density. And honestly, the no-go option after today, if it remains a single family, we would put it on the market immediately. That is the no-go. And I don't know how long it takes to, it's been boarded up. You've seen pictures. We're winterizing it. We're reducing our exposure to operating expenses because we just have to. We just have to do it. It's $30,000 a year of mortgage payments and just holding costs, electricity, different things that we still need to keep running in the building, real estate taxes, insurance. So that's my justification for the reasonable yield. So this event is not of our own making. That's the other big point. We really came into this without knowing that. You might say, well, we are a very experienced group, but why didn't you know this? We've just been lucky with rental certificates in the past. We've always bought properties with rental certificates. We started buying properties that were a little bit more blighted, a little bit more difficult in different neighborhoods, because margins pushed us out from the Drake neighborhood to the Riverbend neighborhood or the South Side. We have not much experience there. Started buying the last 2 years. So the broker style did not disclose that, and it's very evident with the bank loan documents, appraisals, everything was bought as a 7-unit. Because that's what we're used to, is buying something that's multi-unit and then turning it around. And we're a buy and hold company. So these are some quick pictures of the units at 1900 specifically, at acquisition. We took some pictures. It's very cluttered, dirty, it's not in good condition. This is my opinion. Some others here may have different opinions, but we don't believe there's too many historical components to be preserved. Some pictures of what it looks like right now, the bottom units. These are the ones we remodeled on the second floor and third floor. It's kind of the template of what we would do. As you notice, the windows need work, and that's why we call Catherine and the staff out, just to understand the process. And here's the property that's north of 1900. It's a 3-unit apartment. These are the before pictures and some after pictures. They're fully occupied right now with rent-paying tenants that are a good fit. This is the building 2 doors down that we own. It's a 5-unit apartment. That's the condition. And we staged this one for pictures. And it's fully occupied right now as well. This is another Riverbend neighborhood property, zoned apartment. It came very blighted, such as this, out-of-state investor. We changed it around, and it's fully occupied right now as well. This is opposite the YMCA grub that we're trying to make expansions for as well. This is a fire escape. I just want to demonstrate that we do spend money on capital. We just got this done. This is the original fire escape on the left, and then the right side is we spent $110,000 redoing this year to be compliant with the city. This is the Riverbend house that was a 5-unit that we bought as a 1-unit, that was downzoned as a 1-unit, so before and after. So just some quick stats here. So the cluster of hearts right in the middle, that's where that portfolio is. 1900 is right in the corner. The other heart right there is where we have the other property that I just mentioned, the 15-unit apartment. There's a lot of good things happening in the neighborhood. Neighborhood's very passionate. I mean, it's been a pleasure getting to know them. Even yesterday at the holiday party, I got to know quite a few more of them. So we want to be an integral part, and we want to continue contributing to this neighborhood.
Becky,
Yes.
I'm going to give you about another minute or so.
Yeah.
You've already had almost 12 minutes of presentation time. Yeah, you're a very professional presenter. This is one of the best I've ever seen on a presentation, but if you could kind of move
Sure.
on.
No, we just want to wrap up and show this slide. So this is something we got from an architect that's a guy that does a lot of historical work. So he said, hey, can we move it to the back side of the property? There is potential in doing that. We don't have all the stats yet, but this is a potential recommendation of moving the egress, because that's not nice to look at, if you can tell from the front of the property. Other than that, questions, please?
Okay. Yes. Do we have questions for Becky?
So I just want to understand your timeline here. So the rental certificate expired on the 9/7 of '20. It was discontinued of 9/8 of '21, and you guys bought the building in April of '22. So it was expired when you bought it,
Yes.
and no one disclosed that to you.
No.
And because you've been doing this all along.
Yes, that's
And was this being marketed as a 7-unit?
yes, offline, off-market. It's an off-market deal. So it's not, I think if it's on market, it would be a lot different story. But I feel like it would have been marketed that way if it were put on the MLS or LoopNet or any of that.
So my ignorance in real estate, off-market meant You knew somebody wanted to sell, but it wasn't being advertised?
Yes. So we have a similar issue at 1082 21st Street, but
Okay.
it's zoned the right way. It triggered an exterior site plan, and a year and a half later, with maybe $150,000 of extra work, we are finally getting done. One example, and this is all happening at the same time. So we're learning a lot, absolutely. We'll never make the same mistake again, and we've tried really hard since May.
So what does the real estate agent say when you ask them this? Do they just shrug their shoulders saying, oh, tough?
So, well, I I politely mentioned this to him in June. I don't know what the repercussions may be after this.
Well,
So,
Okay.
but I've been coached by an attorney
Yeah.
that it is best in our best interest to mitigate as much damages and prove that we tried really, really hard
Right.
to get here today
Right.
before we pursue anything. So,
Yeah.
but the goal is to mitigate damages because we're good
Well,
people. Yeah.
and I don't care if you ever come in front of us again. Most people don't want to. That's okay. But most people come to us and they ask for forgiveness. And in this case, you guys got duped.
most people come and ask for permission. She's asking
Most
for
people come here and go, well, yeah, okay, I realize what I did, and I guess, I hope you guys will look the other way and let me get away with it.
No,
And you guys are not asking for that. I need you to hear you say that because I'm putting the timeline together, and we get a lot of smart people in here that try and run stuff past us, and it's a waste of our time, and we know exactly what's going on, and I'm not interested in catching people doing stuff wrong. It's just, come on. So I'm completely sympathetic with what you're dealing with right this minute. It's too bad.
It is
So,
been
Anyway,
yeah.
this is a public meeting. This is on the news, too, so whatever.
Okay, yeah. Any more questions?
So Becky, you said this is part of a 16-unit buy, and I know you're talking units. I like to talk properties. How many properties were part of these 16 units?
Right here, so.
Okay, they're all
Yep.
kind of connected there.
That L
Okay,
right there.
okay.
Yep, so there's 7 units right there, 1,900. There's a single family right next
Okay.
door.
And I don't
Five-
want to spend a lot of time on the math, but you had your table of value and you had your table of loss that went with it. I understand value, but within your 16-unit buy, did you figure out as a percentage or proportion,
Yes.
what is this property? How much did you pay for this property?
265,000.
All right.
And we've spent over 100,000 so
Right.
far on some rehabs.
And you said that as part of that, somebody had owned it, then somebody bought it for a day, and then you got it the next day. So
Yeah.
did that mean you kind of saw this train a-coming somehow? And why was there a party in the middle that owned it for a day?
So the ownership group, EBC LLC, Brad Lowe, Spire Group,
Okay.
so they manage and own a lot of things, and they just have a relationship with Community, I think, Choice Credit Union, one of those banks.
Okay, sure.
So it's, a middleman opportunity to flip things for a day and 30 days later close on it, and it's a sandwich deal. So they double close on it without really putting anything up.
And that kind of gets beyond me, but you had an idea that there was going to be a little pop the clutch on owners here.
Yeah, as long as our underwriting works, we don't
Okay.
care what we
Okay.
paid the seller.
So
if
this
you
is
will.
going to get to my next point. So you were anticipating buying this place, and I know you said you relied on your broker's information.
Mhm.
You had one of the nicest presentations I've ever seen, both like verbally and here. But one of the things you had is you have a great relationship with local authorities, including the rental inspectors. Why did you not pick up the phone and call one of these people and go, hey, we got a chance to get a great deal here. Now remind me, what do I need to do for building permits or any zoning or rental certificates? Because we want to pull the trigger tomorrow. Why didn't you do that?
We've never had issues in the past.
Well,
No, I mean, frankly speaking,
and
we've
I've been on
always
this-
done.
I've been on this board a long time,
Yeah.
and I know that, and we've seen this before, or a broker, real estate agent, a bank, or even a realtor will tell you, oh yeah, it's zoned for a 7-unit apartment, according to the Polk County assessor, who all they do is value properties. They don't give you legal determinations on uses. I feel bad for you in this case, but you're not the first one, and I think Dave alluded to this, that's gotten in front of us because you made the mistake of not checking on these things first. And then you jumped in with both feet and into a very shallow pool here.
I mean, I have to say that is true. I'm not
Yeah.
going to lie.
Yeah.
It is true.
Yeah, so under the variance test, I think the struggle that we may have here is the variance has to be something related to the property in question, not because, gee, it'd be too expensive to do this, or, gee, sorry, we didn't check on something. A variance can't be granted because of situations that are of the owner's own making. And that's a tough one for us to get over the hill on. So that's why I wanted to ask you some questions, listen to your presentation. But yeah, and I know this has been tough for everybody. You've been in front of the Planning and Zoning Commission twice, to no avail, City Council, no avail, and now you're here, right? Yeah, and we are the nicest personal people. It doesn't mean our decisions are any different or based on the same things as others, but the way we look at this, our variance test, that is our legal thing that we look at. So, anything else, Dave?
Yeah, run real quick. You need 7 keys to make the math work, to make this thing
Well-
fit in your bucket for your portfolio.
Well, I think if Rhonda knows this, probably any density helps
Yeah,
at
right.
this point.
Beyond single family.
Beyond single family.
Yeah, but 5 work?
5 will help.
Is-
Will help.
Would you keep the building with 5?
We will finish a job at 5. I think, but we have to see what the application looks like. I have to go back to CDBG funding to get that figured out. So that's something we have to consider is like, what is our probability of success with the application? It takes a long time as well.
Yeah. How many square feet are in these if there was 7?
It's 4,000 plus square feet total, so it's roughly 600 square feet per
So
apartment.
these are like efficiencies then?
One unit,
Or
one
one
bedrooms,
bedroom.
one bedrooms mostly. There's one efficiency unit. Yeah.
Right, no, yeah, I know that, okay.
Yeah.
And are there any other you bought 16 this portfolio, how many buildings did that include?
4 right there. So
Right.
So
middle.
it's 4 buildings and
4
they're all
buildings.
multi,
No. The one next door is single family, but it came as a single family.
Yep.
so you knew that going into it?
Yes.
Okay.
Yeah. It's more so the awareness and the piece of paper that's been.
Is there a higher likelihood that you'll get approval and get this funding if you have 7 versus 5?
I do not know that. I do not know that answer. And this is something that Lisa Krabs from the city may have an answer to.
And you also said that you would look at low income for this?
I am capped. I am capped at $889 a month using that funding.
Okay.
And our rents are below that anyways. The market is the market.
Yep,
It gives us what we can take.
yep, okay, all right.
Yep.
Thanks.
Good questions, Dave. Anybody else? Okay, seeing none, thank you, Becky. We'll give you a chance for a rebuttal here at the end if necessary. Is there anybody here to speak in support of the applicant? Seeing none, is there anybody to speak in opposition to the applicant? Come on up. We need your name, address as appropriate, and you've got up to 5 minutes to address the board.
Okay, thank you. My name is Diana Rezak. I live at 1917 Arlington. I live across the street. I oppose this issue because my neighborhood is saturated with rentals. Within a block radius of my house, I have 95 units. And I really did not believe that until I started walking my streets. Okay, so I have 95 of these 95. 4 are actually rental complexes. 1805 Arlington has 36 units. 1940 Arlington has 9 units. 1959 Arlington has 6 units. And 253 Franklin has 24. Plus, within my area, I have 6 family residents that have been converted to 20 apartments. 1820 Arlington is 14 units. 1908 Arlington is 3 units. 1924 Arlington is 2 units. 1944 Arlington is 2 units. 319 Franklin is 5. And 1825 Oakland is 4. Plus, the opposition to this is also changed by who owns 3 of the neighboring properties. If you're looking at the map in front of you, you will realize that Starlink owns part of the neighborhood. They own the neighborhood houses. I do not oppose being rental. I am actually a landlord, and I have rental, and I have low-income rental. I have a river house in this neighborhood which rents for $700 plus utilities. And keep in mind these numbers I'm giving you, my backyard is the Des Moines River. So this is a very, very dense neighborhood. So I would appreciate you not adding 7 more units to my neighborhood. I thank you for your time. I actually listened to one of your meetings to prepare for this, and I really appreciate your patience on some of these issues, especially ours. So thank you very much for volunteering, and please do not add 7 units.
Appreciate you coming down. Thank you for your comments. Anybody else that wishes to speak in opposition? I'm not going to make you restate that one. But we do need your name, address. You got up to 5 minutes.
Pardon me, I would like to get to the picture that was included in the packet before I start.
Yeah, staff may need to help you. That may be a separate document.
Oh, here it goes. I'm sorry.
in
I
there?
don't mean to take time. Maybe not. Well, there was a photo in the packet of the building that you clicked on.
Yeah, staff can help.
Thank
from
you so much.
Remote here.
Thank you, thank you.
Is that the picture?
That's it. There we go. Thank you so much. Mr. Chairman, members of the board, my name is Kathy Hellstern. I live at 803 Hickman Road, and I am currently the president of the Riverbend Neighborhood Association Board. I am here as their representative. First of all, thank you for inviting us to provide input in this process. We take this responsibility very seriously. We have spent the last 5 months having difficult conversations about this complicated situation. We didn't cause this. We did not initiate this process, but it has brought tension to our community for months now. I say this so that you know that our decision was not made lightly. This has been hard. You will have noted in the letter that we submitted that it is the majority decision of our board to request that you deny this use variance at this property. While we want to build our relationship with the owners, because they do have investment in our neighborhood, we have seen firsthand how a reduction in density has helped our neighborhood to stabilize, which is a positive outcome for all neighbors. Longstanding neighbors, new neighbors, and those neighbors who will find affordable housing in Riverbend. Everyone deserves a stable, well-planned neighborhood to live in. This property sits at a very dense corner, a corner that has been and still is home to nuisance properties. Density reduction is the one tool we have to keep moving our neighborhood's recovery process forward. The opportunity for this at this corner is right now. You can see how these properties are used and abused in our neighborhood by the very process they went through to purchase it. We also have to think about the future of this property. Even if the current owner has the best intentions and operates their rental properly, this variance stays with the property and becomes permissible to future owners. We have seen how quickly things can change for a business, so there's no guarantee that the current owners would hold this property for the very long term. This means we have to prepare for the future because we are the ones left living with the permanence of this decision. Our hardship is what irresponsible landlords can do to our community and the place where we live. We have worked with use variance conditions at other properties in the neighborhood, and our experience is that they are difficult to enforce and take an extreme amount of nuisance to even get attention. We don't feel confident that conditions would do much to protect everyone from bad actors. We also have deep concerns that if conditions were enforced and an irresponsible owner caused the use variance to be revoked, then the residents of the building would lose their homes. This does not create a secure and stable environment for either the residents or the neighborhood. Really, what it does is create one more place where we as neighbors have to be vigilant and become the monitors of regulation. This is not my first time here, and it won't be my last. Thereby, we maintain this tension between us and the property. It's just not healthy. We do understand and believe that there is a dire need for housing stock in Des Moines. We support density that is responsible and intentional. The support is evident in the many projects that we have championed on our 6th Avenue corridor. Unfortunately, conversion homes have been a risky kind of slapdash density since the beginning. These homes are usually quickly chopped up into units so a descendant, a developer, a new property owner can drain the most possible money out of them. As you can see from photos of this property, there is usually little to no care put into them after that is done. If the last 80 years have shown us anything in our neighborhood, that this is not a healthy way of creating housing. It puts neighborhoods, residents, and neighbors who don't have a lot of options for housing at risk, all for being able to check created housing off the list. You'll see in our submitted letter that just as your staff did, while we recommend denial of the variance, we ask that if you do see fit to allow it, you consider some conditions that would hopefully help protect the neighborhood and the neighbors. Please consider those carefully so that we have a way of clawing back this decision in the future when an irresponsible owner causes the property to become a nuisance yet again. And if you have any questions about those conditions, I would be more than happy to answer those. I just don't want to take time if unnecessary. That's my piece. Thank you so much.
Thank you, Kathy. Did you time that at home?
I did. I've done this before.
Yeah. 5 minutes, 20 seconds. I'm a nice
I'm
guy.
so sorry. Did you get the copy?
Does anybody have any questions for Kathy? All right. Thank you for coming down, Kathy, and thank you for your service to your neighborhood. Anybody else that wishes to speak in opposition?
Good afternoon, Mr. Chairman and members of the commission or the board. Apologies. My name is Chad Nelson. I live at 1236 9th Street in the historic Riverbend neighborhood. I am also a board member for the Neighborhood Association. I'm also a commissioner for the Historic Preservation Commission. Cool. I am also an elected board member for the International Preservation Trades Network. I belong to the Window Preservations Alliance, which is the preservation network for window repair, and the Window Preservation Standards Collaborative. I like preservation, and I like restoration, and I've been to all of these. I've been to the 2 planning and zonings. I've been to the city council meeting. I've written letters for all of them. I'm tired. I did not write a letter for this one. I've just internalized this at this point. So I'm just going to start. When I first moved to Des Moines in 2007, I told my college friend that I was moving just north of downtown Des Moines. Where I was actually moving was Park Place Apartments right next to Scotty Wright Consistory. What he thought I meant was I was moving into the Riverbend neighborhood. His eyes got as big as dinner plates, and he says, you cannot move there, it is not safe. This was 15 years ago. It's my understanding, I've now lived there for 4 years. My husband and I bought a house built in 1888 that was once 6 apartments. It has been converted into a single-family home. Over the last 2 decades, the density reduction has been the primary tool that the neighborhood has used to increase safety. I'm very pleased to announce we just got the most recent crime statistics. There was 145 police calls. Only 2 occurred within the Riverbend neighborhood. This has not always been the case. When we moved in, we've talked to neighbors, our direct neighbors, whose house has been in the family for 4 generations. They were sitting on their front porch. They were watching drug deals go by in the house next door to them. They were watching prostitutes work, sex workers work the corner across the street. They bought the houses in order to get the drug dealers out. This has just been what this neighborhood has dealt with for more than 20 years, for decades. This neighborhood has been disinvested. People ignore us, people pass problems into the neighborhood, and we are promptly forgotten about. So, part of the plan is the neighborhood decided to make this a historic district. So you see the house as it stands now, and they say that it can't be restored. We just had our historic home tour. There were 12 houses on the home tour. 11 of those houses were once multifamily apartment complexes. They have all been reverted back to single-family houses, mine included. The house across the street, which is about the same size, belonged to Mike Hildebrand. It was 8 units. It's now worth $450,000. He converted that back to himself to a single-family home. So what I am asking is to allow this neighborhood a chance to restore itself back to its former glory, to allow us to restore the historic fabric that has been lost. These houses that have been converted to apartments have been neglected. We've lost so many already. If you drive down our streets, there's empty lots, and there's new infill housing built by Habitat for Humanity or Anna Wim, which is fantastic, but they are not the original structures of our neighborhood. We're being denied our history. We can't effectively move forward without identifying where we came from. And this fits in with the Reflect DSM plan, which was just approved, to promote the educational, cultural, economic, general welfare of the public through the protection and enhancement of districts of historical significance, which Riverbend is, to safeguard the heritage of the city by preserving districts in the city which reflect the elements of its cultural, social, economic, political, historic, aesthetic, and architectural significance, which this house specifically has architectural significance if we were allowed to repair it as it needs to be repaired, not to put a slapdash finish on it so that it can pass a rental inspection. Stabilize and improve property values for the equity of all of the citizens within the neighborhood and their property. Foster civic beauty and pride. Protect and enhance the city's attractions to tourists, strengthen the economy of the city, and to facilitate the rehabilitation and revitalization of older neighborhoods. We can't restore and revitalize this neighborhood if we continue to allow landlords to come in and do the same thing that has been done for decades and has failed. The neighborhood is in the state that it's in because we keep doing this. We keep trusting landlords to do the right thing, and it's not working. We have to try something different. You have to give this neighborhood a chance to fix itself. So please deny this variance. Allow this to be a single-family home, which it was built and which is intended to be. Thank you very much.
Thank you, Chad. Anybody else that wishes to speak in opposition, please step forward. Just need your name, address, and you've got 5 minutes.
Hi, I'm Dave Hellstern. I live at 803 Hickman Road. I'm an attorney here in the Metro. I'm the treasurer right now of the Des Moines Historical Society, and I'm also a board member of Home Inc. that helps people with attain a home ownership. It's based out of Riverbend. You guys, I was about ready to pull my hair out. Yeah, you got the timeline right. The rental certificate lapsed in 2020, September 7, 2020. I found that out because I called the Des Moines Neighborhood Inspection Office. I talked to a very nice lady. It took 5 minutes, and I found out that date. She just looked it up on the computer. These owners could have done that at any point between September 7, 2020 and April 26, 2022, which is what date the warranty deed shows that they took possession of the property. So I don't know if they got bamboozled or what happened. All I know is they should have done their due diligence. Somebody probably owes them some money. If it's an attorney, they got malpractice. If it's a realtor, they've got insurance. It's not the Riverbend Neighborhood Association that should allow them to have 7 units. That train has left the station. And that's the whole reason that we have this Riverbend neighborhood plan in place. It was to try to reduce density. At one point, every one of the houses on my side of my block were apartments. My house itself was cut up into 4 apartments. Almost everybody I know has a house that at some point were at least 2 or 3 apartments. That just is what happened to our neighborhood. But it's because of this conscious effort. And back in 2008, you guys kind of questioned as to why everything's all zoned this way. In 2008, the Riverbend neighborhood actually got the city to downzone everything in Riverbend to reduce density and to open up home ownership so that when these rental certificates lapsed along the way, these houses would go back to single family and allow people to buy them. And so that's what we're asking be done here. It's part of the Riverbend plan. It has been since 2008, and it's working. It is really working. We're not against rentals. What we want is rentals that were built as rentals. A prime example is the other property that Credo and Starlink own, and that's the Gables on 9th. Those were built as apartments, and they're great, and they've done a great job with them. So we're not saying no apartments. We're saying use the buildings that were built as apartments. This, if you could pull that overhead picture. This house was never supposed to be apartments. They own the house to the north of that. They own the two houses to the left of that. They're all renting those out. As other neighbors have talked about, there's rentals all around there. This is a highly congested area. We've got Franklin and Arlington. A lot of people use this as a quick way to get across from 2nd Avenue to 6th. And so there's already too much congestion. This is not a good spot for a 7-plex. And then if you could go to the first page of the report. I know the staff's recommendation was for 5. This is zone N5. And so pursuant to the table, you can only allow up to 3 or 4 households. You see that third column down? You cannot go 5 to 8. That's got that line across there, and the line says prohibited. So I don't even think that's an option to go to 7. We're saying no, it should just be allowed to go back to single family. And so we're saying no, don't allow any rentals in there. Axios reported last month that the number of households with 3 or more generations living under one roof went up 18% between 2010 and 2020. And that's who we're seeing are buying these properties, and we have a lot of interest. We had one property, it was 1321 8th Street, went on the market September 8th. It was smaller than this house, 3,000 some feet. It had an offer within 4 days. So we have the market for single-family homes. So please allow us to have this one be a single-family as well. Any questions?
Dave, that was 5 minutes and 10 seconds, even better.
Thank you.
All right, appreciate you coming in. Anybody else to speak in opposition this afternoon? Seeing none, is there anybody that just wants to speak in neutrality, yet related to the issue at hand? Seeing none, do we have any further questions for city staff or the zoning enforcement officer have anything?
Yes, if there's any questions about that determination or anything like that, those are the federal funds.
No? Looks like we're good. Okay. All right. So rebuttal. Becky, you have up to 3 minutes to close us out here. If there's anything you'd like to add or summarize or respond to?
Yeah, I mean, everything I've said today is true. But I think it's easier to be in a position living in a neighborhood. I know I don't live there. I live in Des Moines, not too far away. But they are stakeholders and not exactly in the same position as I am right now with the financial impact that we have. I know a lot of them say, hey, single family, but getting to a single family will be difficult. Some of them say, I mean, we have to probably sell it as land value for someone to buy it at, or some kind of grant needs to be had to get it rebuilt as single family. A lot of them took time over 15 years restoring it to single family. That is not our business plan or our company's mission and vision. So we want to remind everyone of that. And then there's been a lot of speculation about future landlords of this place, not us. I think we've proven that we're local, good landlords. We've done good in Des Moines. And what happens after we sell? I think it's no different than anyone in the neighborhood having homes or rentals. They have the ability to do the same thing. So why speculate on us? That is a little bit unreasonable and unfair. Then the other thing is there is a parallel in hiring the best talent. Like we just had a hiring process for a new person on my team at work, and the flight risk was a contentious topic. The person of hire was from a different state, and Iowa hires Iowa talent because it's sometimes difficult to attract talent from New York or Chicago to come to Des Moines. And it's not very diverse as well. I'm here a long time because I went to school here, I know Des Moines, I live here. But it's not easy to hire that kind of talent in the same pool. So I think it's unreasonable to speculate on the future of this, what happens next, when we have proven so far that we are good landlords and we are gonna finish the job if given the opportunity. So, thank you.
Okay. All right. Thank you, Becky. Okay, well, that concludes the public portion of the hearing. So now, as board members, we'll close public portion and deliberate and see if we can make a decision here. Does anybody want to lead us off?
I was just wondering if legal could kind of go over the variance test a little bit, just to put that in perspective.
The general variance test?
The general variance test, yes.
Okay, yep.
Yeah, so it's laid out in the staff report, and that comes also from our ordinance, and it also comes, the ordinance comes from case law interpreting the state code. So the variance test is set out by state law, and then our ordinance is adopted pursuant to both the codified state law and the judicial interpretations thereof. So the first part is that the subject property can't yield a reasonable return for any use that's permitted by the subject zoning regulations. And there's some more detail that's in that part of it I can go into if you'd like me to, but that's generally the test is that there's no reasonable economic return. The second part of it is that the plight of the owner is due to unique circumstances that are not of the owner's own making, but they relate to the specific property rather than a condition created by the owner. And finally, it's that the use, the contemplated or requested use would not alter the essential character of the area in which the property is located.
Thank you very much for
Yeah.
that. I think there was quite a bit of testimony today about just, the intent of the designation of the neighborhood, that there's an intent there to have single-family dwellings, that there's an intent to try to decrease the density. And as just stated, the variance test is a very difficult test to overcome. Yield any reasonable return. It's a very high burden to prove, and I think it goes, as pointed out by some people, that actually a return could be highly profitable on this type of single-family dwelling. So I think that I appreciate the mission and vision of this company. I think they do a good job, and I think, the fact that they're trying to rent to a diverse population and a diverse socioeconomic status is great, but I think the test is the test, and I'm going to be voting in favor of denying the variance because of the variance test. Thank you.
Do we have some other thoughts by the board?
I just need to say I agree with everything he just said.
Cool. I might throw in a bit as well on this. Yeah, I want to give Becky a lot of credit here. Great presentation, great business. Sounds like a heavy hitter on getting things turned around, but you missed an easy pitch here. For a company that has so much experience, nobody checked the zoning from your company, your investors, your co-owners, your employees. Nobody checked anything on that. Nobody bothered to talk to the city's rental inspectors to go, hey, the rental certificate expired here. You jumped in and bought it. You bought it because it was a good deal. It was a good portfolio. I go to lots of estate auctions, and I've learned over time. You see some collectible vase or piece of furniture, you're like, oh my God, that's a good deal. You grab it. You got a good deal on it. You take it home. It's got a chip in it. It's got water damage in it. It's not quite what I thought it was. You learn from that. You guys leaped and you didn't look on this one. And when I see what the intent of a zoning ordinance It's over 100 years old now around the country. It's constitutional to have land use controls for development. But a zoning ordinance doesn't take away somebody's right to continue to use the property as it was when the zoning ordinance changed through what's called grandfathering. I don't want to re-explain it for 10 minutes, but the idea with grandfathering is if that use discontinues, now it is time to catch up with the new zoning. And the new zoning here is actually going back to what it used to be 100 years ago, which is single-family district. So there were plenty of chances for that grandfathered use to have continued, but the key thing with a zoning ordinance, not to get anybody, but to move a community forward, is when those uses expire, the rental certificate expired, somebody let it go. Now it's time to look at the future, and the future in this neighborhood is a single-family district. And this is tough, and I don't like to do this, but that variance test is also tough. And everything we've seen here, the plight of the owner is not due to unique circumstances. It's due to the owner's own making. They didn't look. They trusted a broker or a realtor. The people they should talk to are down at the Plan and Development Center. They could get a reasonable return on this property. It just might be more profitable to do something else. And based on, that was the staff's recommendation for denial. If there's other folks who want to do something else, great, but staff sometimes will throw out a lifesaver of, well, if you want to grant a variance, please limit it to this. If somebody wants to look at that, fine, but I would agree with my colleagues here. I can't get over the variance test, and I can't look past the direction this neighborhood's supposed to be heading in. So I'd have to say no to. So, does anybody have any other thoughts or any other contrary thoughts or a motion? Would there be a second for that?
I second.
Okay. So we got a motion to deny the variance request from Marlis, second by Justin. All those in favor to deny the variance, raise your right hand. Say aye. 1, 2, 3, 4, 5, 6. Those opposed? 1. Okay. All right. Good thoughts here by everybody, but unfortunately, the variance has not been granted. I would encourage the owner to work with the city on how they can rehabilitate this property and work with the neighborhood association, Historic Preservation Commission, and move the property forward. All right, so that concludes that item. Number 9 had been withdrawn, so I do believe that let's cover minutes. If you were here at the last meeting and reviewed the minutes, are there any changes? If none, would there be a motion to approve? All right, motion by Marlis, second by Rhonda. All those in favor who were here last month, raise your right hand, say aye. Okay. We missed anybody? Was Tom here last month? Tom? Yeah, all right. So was that all 7 of us? Okay. Yeah, all right. All right, so minutes carry. Do we have any other business? No. Okay, so no other business. Therefore, this hearing is adjourned.